All right. Hi, this is Curt
And Brad Pinsky.
and we are here for another edition of Fire Law Roundup for September 30th of 2024. I'm coming to you from Phoenix, so I'm not sure how the logistics of this are going to work, but Brad, go ahead. Take us
You're a
away.
big talking head today. Okay. So for the listeners, hold on. Any one of these cases could be 2 hours long. Obviously, we won't do that to you, but we have some really good stuff. Today, it's a great week. It's a great week for the lawyers anyway. So let's start with, we're going to go to Muncie, Indiana. And you and I were very critical of this. So what happened was, as I recall, there is a test being given. There's a captain who's proctoring the test and is helping people prepare. And like all other exams, when somebody's done with the exam, they maybe write down questions or they remember the questions and they talk about it, and we review past questions. Like, for example, every book that exists on Firefighter 1, Fire Officer 1 are all databank questions, right? And there's similar questions that have come out of the exams to help you prepare. In fact, some of them are identical. So here, the captain was accused of cheating and allowing students to cheat by providing them past test questions, as I recall. And you and I were incredibly critical.
I think there was a couple of questions. There was EMS related, and there were fire related, and there were some allegations that he was giving answers to the students during the exam, which I've had that done. I have never done it, but I know I've been through. Check the box. For example, at one time we used to have to do annual CPR.
Right.
You've got to do your annual sexual harassment training. You got to do your annual confined space rescue refresher. You've got to do your annual this and your annual that and your annual this and your annual that, and at some point, some of this stuff just becomes check the box activities. But there's other things that are not just check the box activities. And drawing the line sometimes can be difficult. And I'm not making excuses for him, but it becomes difficult.
And that was also basically one of his arguments, frankly, right?
Yeah. But there were allegations, I think, in this case, that were made by people who maybe had a grudge against this person, or maybe were trying to take him out politically and for promotion. And I don't know. It just. Go ahead.
So initially what happens is he loses all of his EMS certs are revoked, which basically rendered him unemployable, right, as a firefighter and EMT, et cetera. And so he appeals it. It goes to administrative law judge, and he argues that he was simply trying to help his students prepare for the state and national exams, and that, as you said, the allegations against him were motivated maybe by people who weren't on his side. So the ALJ holds that there was insufficient evidence that he showed the questions and answers during the examination, but the ALJ still found that he was guilty, right? And not as serious, but also concluded that the punishment was too hard. So he rescinds the punishment, but they alter it to say, well, we're going to revoke your ability to teach EVOC, and we're going to suspend your other fire certifications through the end of 24. And he's on probation for 5 years. I still blatantly disagree with this whole thing.
I'm troubled by it, and I'm troubled by what exactly is cheating. Now, if you give me clear rules on what is cheating, and one of those rules is you cannot quiz students on past exams and build a database, then it's pretty clear you're cheating. But I don't know about you. I went through Barbary to prepare for the bar exam back
all past exams
40 years ago. Okay. Where does Barbary, for those of you who aren't familiar, there's several testing companies or practice testing companies out there that help prepare people to pass the bar exam. And there's things for the medical boards and so on and so forth. Where do you suppose Barbary gets its questions from?
Yeah, exactly. They're all past exams.
Old exams.
In law school, we prepared for the current exam by taking the past exams and reading the answers.
So, and again, what is the problem here? Now, again, I don't know about Indiana. Maybe their state fire academy and the EMS division has strict policies on instructors and so on. And if you stepped over the line, he deserves to get punished. But if there are no rules and you're just going to go after somebody for doing something that we don't think you should do.
Right. And we should draw a line between what happened during the exam allegedly and what happens in preparation of the exam. You and I are really focusing on what happened in preparation of the exam. If at the exam he gave answers, hey, different issue. Right.
That's a different issue.
Or if he allowed, wasn't there an allegation? It wasn't in this write-up, but in the other one where he may have allowed group participation, possibly. I forget if it was that one or another one. But
and again, and I've been through those CPR refreshers where you've been a firefighter for 20 years. You've been taking CPR, and it's CPR refresher.
Right.
Okay. Is that the same? Certainly you do the same thing in a promotional exam. Now we're going to have a problem. Okay. Right. Let's face it. Whereas a competitive promotional exam, it's not the same. Or a certification exam for a certain, whether it's driver operator or, company officer 1 or fire officer 1, fire officer 2. That's a different animal. But, again, hopefully the administrative law judge got it right. I don't understand why maybe some of the earlier investigators didn't pick up on some of the nuances here, but I think for people to say that is categorically wrong, for you to ask someone who took an exam what questions were asked and then build a database, I don't see a problem with that.
There's no privacy expectation for an exam which you give to members of the public. You're not signing a confidentiality agreement. Don't share this. So at the moment that somebody tells you, and even if somebody told you, if I take an exam, you're my teacher, I take an exam and I'm sworn to confidentiality, but I then come to you and say, hey, here were their questions. That's not your problem anymore. It may be mine, but as the teacher who's in receipt of what may or may not have been a true question, that's not your problem. And then sharing it to get people ready. But here's the problem I see. Our entire industry in fire and EMS is based on practice tests, and the practice tests and the books, Fire Officer 1 guide, Firefighter 1 guide, Firefighter 2 guide, they're all data bank test questions, and that's how we learn. So to punish somebody when that's how we learn, that's how we're tested for national exams. I agree with you. If there's something in Indiana that says you can't do it, different issue. I haven't seen that.
Absolutely.
But that's not what we're seeing at the moment. At least that's not what we read. So,
so he's been suspended without pay for 16 months at this point. And now, according to the administrative law judge's recommendations, he's probably not going to be able to come back to work, assuming that he gets past whatever departmental discipline is going to be imposed. He hasn't been disciplined beyond the suspension until this whole thing clears up. But he's now looking at maybe some additional time without pay, assuming that, again, the department opts to, just say time served.
Right. Understood. Okay. Well, let's go to yet an even bigger scandal. This one is, I don't know if you're the only one who's put this together or what, but this is so monumentally huge. And here's the short of it. And look, everyone should read the blog because I'm summarizing, but we have the mayor and we have the Turkish government. The Turkish government is building a building in New York City. Like every building.
A big building.
What's that?
A big building.
A big building, which is, important, and it's going to house, government officials, etc. But like every building, and despite that it's the Turkish government, it is not exempt from fire code, right? For things like fire alarms and sprinkler systems, etc. So the process is the application and the building are being inspected and reviewed by the FDNY. And it's gone to the fire prevention group who's reviewing the fire alarm and sprinkler systems and all the other fire components, etc. A permit's being, I don't want to say held up, it's just not ready until it can't be issued, should not have been issued until the building was safe. So the mayor gets a call from the Turkish government, a friend of his at the Turkish government, I guess, good friend, a brother. They use the term brother.
He's been flying on their airline since 2017. Well, since earlier, he had been flying on the Turkish government's airline, first class, all over the world, to China and a lot of other places.
Something like that.
Yeah. And there was some other questionable donations going through straw people to
right. That's the mayor's motivation, right? The mayor's motivation, and what I'll say he does is presumably he's getting some, nice gifts, gifts, bribes, whatever you want to call them. So the Turkish government's upset that their building isn't getting a permit, so they can't finish it, move in. So what do? They call the mayor. Understandable. The mayor calls the fire chief. Understandable.
The commissioner. The
commissioner, which is understandable. And the commissioner starts weighing in, and I mean weighing in on everybody, chief on down, to get the permit issued. The fire prevention group says it is not ready. We have major concerns, etc. We're not going to issue a permit. And then they are effectively ordered, right, under threat of discipline to violate their duties and issue the permit. Well, what do? You've got a unreasonable, illegal, impermissible, violative, dangerous order, and you've got your job. So I don't question the subordinates filed, right? They did what they did. They filed the permit, issued the permit. So now what we've seen is 2 deputy chiefs indicted for taking bribes, right? Remember, that was last week. We didn't have this before, it came to light with you. We've got 2 deputy chiefs indicted for taking bribes for issuing permits in out of order. Not that they should not have issued, but issuing permits out of order. And the permits are supposed to be taken as they came. But that wasn't the problem. The problem is allegedly they were bribed to take this out of order by this private inspection company or private company. And anyway, so now the things start to merge. Well, wait a minute. Was it a bribe? Are we trying to cover up the commissioner and the mayor? Or was this a mayor's order all the way top down? This is the stuff that small movies are made out of.
And again, I don't know if there's a connection between these two, and I'm not sure that those two were necessarily involved in this particular one. So there's that in the background, but we also have this issue of FDNY appointing a non-firefighter to be the fire commissioner, someone who's a political operative. And very shortly after she was appointed the fire commissioner, we have the same, my understanding is the same fire chief resigning, and several of the, one of the deputy chiefs, who was the fire marshal involved here, I believe, also being threatened with demotion, and him now filing a discrimination suit against the department. And I've got to wonder, how does all of this kind of fit together? There's an awful lot of
we're trying to figure out.
Unanswered questions about how this all fits together, and who may be assisting the U.S. attorney in putting all of the pieces together. So this is going to, I don't think this is the last time we've heard.
No way. Was this a cover up? Was it a whole scandal? Why was this person put in? Right? Was the commissioner, the former commissioner, put in just to cover this up or try to deal with it or protect the mayor? Who knows? But
who knows? I mean, it's
hopefully
concerning.
People are looking into this.
It's truly concerning. And of course, the mayor's saying that he didn't do anything wrong. So you want to leave that open as a possibility as well, that maybe what's alleged isn't necessarily what actually happened. So we don't know. We're going based on, what we do know. We know there's been an indictment of the mayor. We know part of the indictment implicates FDNY. We know you have that second investigation, which may have been something that got uncovered because of this. Who knows? Or vice versa. Maybe that one is what led to this one. Who knows? But not good. Not good.
Nope. Okay, well, I'm sure we'll see more. So let's go to Ottawa. So people will remember, here's the short on this. We've covered this before. We thought it was interesting. I think initially we have, apparently there's a tradition in the fire department, which is strange, that the probationary and newer members fight over chores, literally apparently fight over chores. So there was a firefighter who happens to be non-binary, doesn't identify as either gender. I don't know whether that's necessarily important or relevant or not, but it's part of the report. In any event, so the newer firefighter says, I'm going to do the dishes. And apparently this becomes an issue so that somebody comes up, the captain or whoever, another firefighter.
Senior firefighter.
Senior firefighter comes up behind him And, you know, and this matters because did he grab him? Did he choke him? Does his hand slide off him? Right. We'll talk about what the court found, but ultimately he's charged, right, with assault. And apparently this, again, has a long history, and that matters, because the fun fighting in the firehouse and the fun, right, is different than assault. And in criminal law, we learned there's something called mens rea, intent. You have to have intent to commit a crime. And here, what the judge is basically saying is, look, this is like boy games, right? Childish games. He said the judge found there's no physical injuries or even redness from on the victim's neck, and it strongly suggests that there was no squeezing force used, right? So it's going to, was there even an assault here? And he said, I find the fight between them remained within the boundaries of consensual physical competition, right? It was a fun type of thing. So the judge basically said there's no proof of an assault, of an intentional assault. Now that practice was now ended in the department. They issued a policy banning it. Frankly, they should have been banned forever ago. You know, roughhousing now.
Yeah, I mean but in Canada, right? They play hockey, and hockey is sort of permeates a lot of the culture. And as I'm envisioning what happens there, you've got a senior firefighter who's actually trying to help the rookie, and says, "Hey, I'll do the dishes. You do the dishes every night. I'll do the dishes." And the rookie apparently, they were taught as rookies you push back and you say, "No, I'm the rookie. I'll do the dishes." Right, and so now there's a little bit of hip checking, starts with some hip checking, then kind of progresses into pushing. And then we have physical contact, and the senior firefighter's hand slips off the rookie's shoulder. He's holding the rookie at bay. And by the way, the connection here, why non-binary is important, was there was the firefighter was originally charged with a hate crime, because and I kind of struggle with the right grammar here, but we'll call the victim's name is Ash. But Ash was alleging that the assault took place because Ash is non-binary. So there was that allegation, and those charges were dismissed before the actual trial started.
And all that kind of fits in. If there's no intent to assault somebody, there's no intent to, do anything. It's just It's either joking or it wasn't. It was horseplay having nothing to do with anybody's person or identity or sexual identity or anything like that. It's just, that's what we do in the firehouse. And by the way, if that's what you do in the firehouse, don't do that.
Right. So easy to say at this point in the game, but no one happened to say that prior to this incident happening. Now we've got a senior firefighter terminated, and a captain whose career was, toward the end of his career, certainly jeopardized. And they're both feeling a sigh of relief, both breathing a sigh of relief now that the criminal charges have been dispensed with, but then the discipline, the firefighter is already terminated. So that I don't know if that now opens up an opportunity for the firefighter to come back.
It should, frankly, and really what should do is a recognition that if this was the culture in the fire department, don't blame one firefighter for adhering to the culture.
Sure.
Right? It may be a bad culture, maybe a bad idea, but when the institution allows it, when the fire department allows this practice and knows it's happening, I don't then just punish one person because they didn't realize this was not acceptable. Now, don't stretch that out to be like, oh, well, if everyone's sexually harassing somebody, then that's okay. That's not what I'm saying, right? But here, when these on the line kind of roughhouse, border, whatever, when these kind of things are happening, I just don't think you can fire somebody for participating in it when that's happened a million other times.
Yeah.
So
I agree.
Okay. The next one again. Wow. Let's go to Florida. So here we have a fire lieutenant. She was terminated last year. She's now suing because she's claiming that she was treated differently based on her gender and her age than other exactly similarly situated and less qualified persons. So what happens, and you got to help me because I don't totally get it. So the lieutenant She was a police officer prior to joining the fire department. And at some point in 22, there's some photographs posted from 2009, right? Look, we're going from 22 all the way back to 09. This is a fishing expedition. And they were published to various social media accounts in 2010. We're now going back 12 years, right? Talk about statute of limitations here, right? And again, I'd be saying what policies were there, all that. So in any event, somehow these photographs got to the town, and it showed the plaintiff, the female, along with other people, another lieutenant and other members holding rifles while on town property. And by the time the photographs became available, one of them was already terminated. I don't know for the same or unrelated reasons. But they fire her. And yet, right, she's the only female in the group, and she's the oldest among them, and she's the only one to get fired. But here's the kicker. The other one's not. What's that?
She didn't get fired for the pictures, though. That's again, the facts are a little bit.
That's where I'm losing it.
Okay, yeah, she was not fired for the picture, but the pictures is what started the investigation. So the department starts investigating the pictures. And in the meantime, what they found out was a year or two before, she had purchased the gun, or maybe a couple of years early. She had, in 2017 now, she had purchased a firearm from one of her subordinates, and the transaction took place in the firehouse.
You know, there better be a policy against that, and I can't imagine, despite, our must-have the policies, I don't think we have any policy that says don't do business with,
don't bring fire, like some, and not every department,
yes.
not every department, okay, right. But some departments choose to have a policy that prohibits firearms in the station. I don't know if that department does.
Well, let me tell you about Florida law. Florida law, because I know it at the moment. Florida law.
Why do you know it? Why do you know it?
Florida law says that you cannot prohibit firearms in a parked car as long as they're secured, right? So secured firearms, there's a lot missing from the facts we don't have. Was it secured? Was it in a safe? Was it locked? Right? But, I question whether that would have even been legal to prohibit, saying you can't bring a firearm to the firehouse, because the law specifically says you can, just has to be secured. So in any event, she now is the only one to get fired, but other people who have only 5 years of experience and is 10 years younger and has a bad criminal history, apparently a DUI, not driving under the influence, arrest or conviction, I can't tell, and has some assault or battery issues in the past. In any event, somebody with a little sketchier of a history only gets a written reprimand and then was later promoted. So because this individual, the female, can't come up with any other reason why she's being treated differently, and by the way, that will be for the department to have to come up why we chose somebody less qualified with a worse record. They're going to have to explain that. She's saying the only thing I can come up with, age, gender, and I get it.
Yeah. So she's got a prima facie case. We'll see. It'll depend on whether or not the department can come up with an explanation for why she was treated differently. One may be because she's an officer, and that we expect more. Also, when a subordinate is selling a firearm to a superior, and the superior is willing to look past the rules that prohibit it, maybe it's a little bit more on
if there's a rule prohibiting it, right?
If there's a lot of ifs, a lot of speculation.
Yeah. And look, I don't believe that just because something happened in the past that you can't punish for it now, right? Fine, we didn't discover it back then, but on the other hand, at some point 10, 15 years ago, there really should be some sort of a statute of limitations. I know many places do have like for example, a 1 year statute of limitations. Right.
And I think that's not depending on the gravity of the offense.
And they didn't try to hide anything. It happened at the firehouse. They weren't trying to hide anything. So I don't know that this is, It concerns me. I like seeing decor and decorum. I like formality in the fire service. I also appreciate good joking around. But at this point, we're really beating up the members of the fire service for silly reasons when we have so many other things we could be doing to improve the fire service rather than, this and even the other case. I just,
One of my favorite questions that I ask in my discipline class is, what's the purpose of discipline? And everybody can answer it. Everybody can answer it. They know to change behavior, or get people to do what we need them to do. But sometimes when somebody's done something, we forget, and it becomes about, we've got to fire that person, or we've got to get that person. What they did was wrong, and we haven't even done an investigation yet, and we've already reached the conclusion what they did was wrong, and and they need to be fired. And then that means we've forgotten what's the purpose of discipline. It's not to fire people, it's to get them. Now, understanding at some point, once the investigation is over, once we know everything and all that, that we might not, we might have to fire them. But that's not the purpose of discipline.
and let's go back to the last one, because I think there, right? So we're going to discipline somebody for, assault, etc., for something that's been going on forever. That's the culture. I start to think when I see something gets out of hand, but when I see an employer come in and start disciplining or taking the opposite side of its employees for something that the department knew was happening forever, to me, that's the department saying, well, we let that conduct go forever, but now they did something really, really bad for which somebody's complaining that's going to bring this to light. Now we're going to discipline you. Now we're going to support discipline. And so I guess my point is, when the department realizes that it should have taken action before, you don't cure your prior transgressions, your lack of oversight, your tolerance of improper conduct by now coming out and saying, okay, now everybody's in trouble, right? Why didn't my question is, why didn't the employer stop it forever? So maybe the proper response from the employer, the department, is, we shouldn't have been allowing this. You should know it's not allowed. And from here on out,
said no chief anywhere, anytime.
Exactly.
Okay, because then they've got to hold the mirror up to their face. And when you've got community activists saying, we've got to fire that person, this is outrageous, we've got to fire some, the chief is going to say, oh yeah, I'm not going to say, as a chief, I've been allowing this. I'm going to say, you're absolutely right, we're going to fire this person. Right?
It's distasteful. It really is. If the employer, and it takes us to one last quick point, is, when is it too late to implement a policy to correct something that's happening? And the answer being never, right? It's never too late. So, but I get a lot of questions all the time. Well, wait a minute, we can't change the policy now. We have past practice, which is probably bad in these cases, right? Well, it's going to seem insincere, but we've been allowing it to happen. You can always 180. We can look, we had slavery until 1865. We 180 on that, right? It's never too late to stop something that shouldn't happen. So issue the policy and make it stop. But whether you're disciplining people for adhering to your unwritten culture, that to me is problematic. Okay, last one. I can't believe we got through all that so quickly.
Last one is one of the biggest ones. In a big week, this is one of the biggest ones. And it's not immediately obvious why this one is so big. But Brad, go ahead, man.
Okay, so full disclosure, this is my case. I've got to be somewhat reserved because I'm in court again on Wednesday for this. I have a judge who's clearly taking this seriously, and I have the state of New York who
is the judge one of our subscribers?
No, probably not. I'm hoping not. But in any event, so I'm going to be very cautious, other than saying we're getting the full attention of the court and the state in opposing this. So here's what happened. The United States Supreme Court, in a case called the Security and Exchange Commission v. Jarkessi, held that when a federal agency seeks to impose civil monetary penalties, fines, which have no purpose other than to punish, right? They're not trying to make a victim whole. We're going to punish the actor and we're going to keep the money. That's only, right? When which is step one, when there's a civil monetary penalty, and when the government is using a reason to sue, I'll explain this, that any normal person, any citizen could use to sue, when they're using a cause of action that anybody could sue someone over, in this case, fraud. The SEC sued this guy Jarkessi for fraud, and the Supreme Court says, look, fraud is a common law cause of action. It's something that any regular person can sue for in regular court. So when they put those two things together, the SEC held that the accused in front of the federal agency has a right to a jury trial in court between an Article 7 right jury, a true judge and a jury, with real rules of evidence, not weakened, watered down ones, with real burdens of proof, not one that's like, well, whatever way the wind blows, we can decide. A real one. So that's the Seventh Amendment to the United States Constitution. I have argued, I have an EMT, and we've seen the viral video. It's not that the case is great, that the facts are great, but the law is the law. So here that New York State, not federal, Department of Health is charging Justin Ball with negligence, right? And that's very important to say, and incompetence, which are both, and malpractice, basically, which are common law causes of action, which any person can sue for in court, sue another, and they're seeking a $2,000 up to $10,000 monetary penalty. So so we said, look, we have two theories. One, the Seventh Amendment should apply to New York State in this instance, where we're alleging common law, right? Common law allegations and monetary penalty. That's a tough issue, right? I'm going to be fair. Hopefully this isn't used against me, but that's a tough issue because there are courts who said that the Seventh Amendment doesn't apply to New York State. It wasn't brought through the 14th Amendment down to the states. So it's not my main theory, but it is a theory in this case that the Seventh Amendment applies. And the question is whether the U.S. Supreme Court has changed its stance on the application. That was not the question at federal court. That's a federal agency, right? But what I've then said is, but the state constitution in New York, probably like many other states, have a similar provision which says the right to a jury trial is inviolate, can't be waived. And the question there is whether we should use the same analysis, which is what I'm really primarily arguing. Do we use the same analysis that the U.S. Supreme Court used for a federal agency under the federal constitution? Can we use that analysis under the state constitution? And there I think we should. So we're going to see what the judge says. What's happening on Wednesday is we have a hearing coming up on October 8th before the Department of Health. And I said we need to hold that hearing in place. Otherwise, we're going to go through and have a whole hearing, spending a lot of money, getting a lot of evidence that probably never should come in under the no rules of evidence in administrative hearings. And I've asked the judge, can you hold up the hearing until we can get to a decision on the merits? And
Brad, I think it would help for the firefighters out there, not so much the attorneys that may be listening, but for the firefighters in particular, to understand why a jury trial would be significantly more protective of an accused firefighter than the current administrative procedure.
Well, I'm questioning whether I should say what I should say. No. So look, there's three big things. In an administrative hearing, there are no rules of evidence, meaning and this is true because I do these all the time, I can get up as a witness and say, I talked to somebody who talked to somebody, and what they said is that you're guilty. Right? It's like saying, was the light red or green? Well, if I say I saw the light, it was green, that's one thing. But when I say I talked to somebody else.
That's firsthand knowledge. Something you saw, smelled, felt, or tasted, that's firsthand knowledge.
Right. But second or third hand knowledge, as we call double or triple hearsay, would never be admissible in court. In court, you have rules to ensure that, and I'll relate it to this, to ensure that the evidence submitted is authentic, not tampered with, is real. When people say, this is what I saw, this is what I heard, they have to meet certain tests to even be able to say that in court. So that's one issue. We want rules of evidence before you charge somebody with a civil monetary penalty and take away their certification. We also want a jury so that we don't have an administrative law judge who works for the same agency who charges you, right? So this is a Department of Health administrative law judge in the Department of Health that's inherently biased. I don't care what you say. I'm not saying the judge is biased. I don't know the judge from the hole in the wall, but the process, right?
The appearance.
If you're the state of New York and you have an administrative law judge who always finds against you as the state of New York, how long are you going to keep that person in your employ, right? So there's an incentive to give in, I think, in any event. And then, of course, we want a burden of proof. In court, we have a burden that requires most of the evidence to weigh in the favor of one side or the other. In the administrative world, hearing world, you just need a little bit of evidence. It doesn't mean it's a majority. It's just enough evidence. It could be 2%, 5%, 10% of the evidence favored. One person said one thing that I find credible, and that's enough to find you guilty, right? So in other words, 100 people could say the light was red. One person says the light was green, and as an administrative law judge, I could say, yeah, I like the one person better. All right. And as long as that was a reasonable conclusion, not the best, not the most right, not the preponderance of all the evidence, it's just as long as there was some evidence to support that, a judge in a court later on in appeal can't overturn it. So for those three reasons, we think in this type of proceeding, the federal and state constitutions, I don't care which, guarantee a right to a jury trial. That's our argument. Now, would I have made this argument ever without the Jarkessi U.S. Supreme Court case? Of course not. But that was a landmark decision, which I'm not trying to toot my horn here, which apparently nobody picked up on the significance of that. And you said when we first covered this, watch OSHA and PASH. Now, that could be a little harder because I don't know under OSHA, well, OSHA and then state OSHAs, right? But with the federal OSHA, I don't know whether a regular citizen could sue to enforce violations of OSHA, right? That may be the change there. But EEOC, that 100%, I think you're going to get a jury trial. I have a case. I'm just waiting to file, hopefully, where I can make this argument because I have a case before the EEOC and Division of Human Rights at state level, and that is 100% in line with the Jarkessi case. And since discrimination cases are 70% of those suits or so against fire departments, the SEC holding, Jarkessi holding is huge. This is a big deal. This ultimately, if we're successful in New York State, huge if, right? This is new ground. Win, lose, we're making the right effort. But if this is successful in this state, this could spread to other states or other state agencies where people are getting rights to a jury. Now, this is not going to expand because I already got the question, what about a firefighter in a discipline case with its employer?
Right.
That's not this. This is state agencies or federal agencies coming after you to impose fines and penalties. But there's a lot of that in our world.
Yeah,
definitely a lot of it.
And, you know, I draw some parallels. When I was in law school, I studied bankruptcy law. And one of the colleagues that I was going with was a paralegal in a bankruptcy firm. And we did a lot of commuting together. So we talk about bankruptcy law. And this was when we used to have bankruptcy judges and we had a bankruptcy court. And they were not what we call Article 3 judges. They were not lifetime tenure. They were on a 10-year appointment and so on. And the Supreme Court threw that out and said that you cannot be doing that kind of a judicial procedure without Article 3 judges. These are judges that are appointed in accordance with the U.S. Constitution under Article 3, which is, you know, where all the federal judges and the Supreme Court reside. Their authority comes from. And I see some parallels here, maybe not perfectly, but the Supreme Court back in 1983, 84, when they made that ruling, stood the bankruptcy system on its head. Because for decades, centuries, they had been doing it in a certain way in the Supreme Court. And this, you know, I know people criticize the current Supreme Court. This was not the current. This is the Warren Court or, you know, Berger Court anyway. But they said, no, wait a minute. We don't care that you've been doing it this way. Those people don't have the jurisdiction to continue making those types of determinations. And so the bankruptcy system had to be completely reformed. And I know because I was studying it at the time, and the professor was going, we're not sure. This is what the Supreme Court said. We're not sure how the Congress is going to fix it, but they're going to have to fix it. And it was an interesting time period. But I see some parallels here in terms of how are we going to fix this problem? Well, they're going to fix it. And they may end up having to put Article 3 people as the hearing officers for these types of proceedings.
It's possible. You know, and the state submitted papers today. These are kind of interim temporary papers, as I'll submit, because we're just looking for some temporary relief before we get to stop this hearing while we get to the final decision. But, you know, the state's primary arguments here are, you know, one, the 7th Amendment doesn't apply to the states. maybe, maybe not, right?
I don't know. I don't understand how it can. I
Well,
just
the
I
U.S.
don't
Supreme
understand.
Court has
It's got to apply
held,
through the due process clause of the 14th Amendment. A
the
right to
U.S.
a
Supreme
jury
Court says
trial.
it doesn't. The U.S. Supreme Court has cases, but are they fact specific that maybe
Yeah.
now is changed? If it seems to me, if I have a right to a jury trial at the federal level, I should have that same right at the state level. But even so, I'll take the analysis, right? I don't care which constitution I get. I either have the right to a jury trial or not. And I really do, anyway. So, but one of the state's arguments, look, this is public health, and we have the right under public health to impose sanctions without, without a jury. And I get the point, but the moment you create a remedy, civil monetary penalties, which fits within the holding of Jarkessi, I think Jarkessi controls. That it really is the question. I mean, that's the ultimate question: is does Jarkessi control this whole issue, even at state law, whether it's set through this application of the 7th Amendment through the 14th? I don't know, or is it that the state should have the same guarantee of rights? And how can we have less? How can we have fewer rights? Well, it's New York State, so who knows? But how can we have fewer rights than we would in state law than under the federal law? And I think our rights should be the same. Same analysis. If the state doesn't want to adopt it, we'll go back to the U.S. Supreme Court, see what they say.
Well, stay tuned here, and we will keep everyone abreast of how this progresses, and whether or not it's really going to revolutionize things, or if it's
just an attempt made in good faith that doesn't go anywhere.
You're going to have to have hand-to-hand combat all the way up to your Court of Appeals, and then we'll see where it goes from there. So
we might, but I think we're asking the right questions. Everyone's doing the right thing. Sometimes you got to push some buttons, win or lose. This is what we do. We make arguments upon our belief and see what the law turns out to be. Okay. So.
All right. Well, interesting week, and I'm sure next week will be just as interesting. And hopefully, we'll see you all back again next week for another.